the court that you go to dispute a traffic ticket, those courts hear civil or criminal cases that have a specific component to it that the court either hasn't ruled on, or there's some dispute about how the law should be interpreted on that point. So as it travels up from the lower courts and people can appeal that, they start to move that case from an appeal, the higher court, which can be the Court of Appeal or the Circuit Court, make a decision on that case. And as it travels up the highest courts of this country, eventually, if there's still no resolution, the Supreme Court will then hear the case. And then they have a couple choices. They can make an opinion, they can issue an opinion on that case, or they can issue a writ to move it back to the previous court to rehear it again. So in this particular case, we have a case that came out of California. It moved its way all the way up to the Ninth Circuit Court. So the way that our country too is split up into circuit courts that encompass a certain amount of states and territories. So California is in the Ninth Circuit. This case moved its way up all the way to the Ninth Circuit, where they came up with a decision, but that decision became appealed, which means that now the Supreme Court chose to hear this case, and they'll be hearing the arguments on this case today, I believe. And the way that works is not typically how you see on TV, right? So on TV, we see a trial where there's two attorneys arguing to a jury. It's actually very different. In the Supreme Court, you're standing next to or behind a podium, essentially. You can't really move. And all 9 justices are sitting at the bench far above you, actually. And the Supreme Court's a lot smaller than we think it is in person. So it's fairly interesting, something I like to nerd out on, but not relevant for the purposes of this broadcast about how the Supreme Court really works, but wanted to give kind of an understanding of what we are going to be talking about today and how the decision is going to impact our everyday lives. So the Cedar Point versus Hassid case was originally, I believe it was the fact pattern or the facts of the case date back to 2005. So in 2005, the Cedar Point Nursery in California, which is a strawberry farm, it was in the middle of harvest season, and union organizers had come on to the work site with bullhorns in hand and started to call workers to unionize. At that point, the Cedar Point Nursery filed in federal court arguing that there's a law, basically, that would essentially make it so that they can't be on that property because it constitutes as a taking. So let's talk about what taking is, because I think that's at the root cause of the plaintiff's argument, is this whole idea of what a taking is. So there are 2 kinds of takings. And under the Fifth Amendment, which most people study and they learn a lot about, in middle school. Under the Fifth Amendment, the government cannot take property without just compensation. So they can't take your property, they can't take my property without just compensation. So this is one of those situations where we have a per se taking versus a regulatory taking. And so this issue of takings is what's being argued. So the plaintiffs are saying that there is essentially a per se taking because the workers are allowed under the, I believe it's the National Labor Relations Act, are allowed to enter upon the property of their employer site 1 hour before work, during lunch, and 1 hour after work. So they're saying that this 1 hour before work, that the plaintiffs, specifically Cedar Point, Cedar Point Nursery is the plaintiff in this case. They're saying that by being on their property, by taking up space, and by being able to exercise ownership of a piece of their land constitutes as a taking by the government, which and they're not being justly compensated for that. So it's kind of an odd argument, and how it relates to unionizing is pretty interesting. So the way that the way that they are trying to make this argument would have implications on whether the government can actually come in and install sprinklers, for instance, to make sure that fires don't start. It also affects when the government wants to come do a inspection on whether the buildings in the Cedar Point Nursery are actually earthquake proof. So this could have implications on workers' health and safety, because now they're saying basically, because of this taking, because we are allowing anybody to walk into the property at any time, that the government can just walk into our property and take over and not provide us money for it. When in reality, these are very necessary things that the union workers, union organizers, often fight for because of the lack of care that a lot of these employers give to their workers, because it's cheaper to do that. So in this particular case, we have that kind of conflict where Cedar Point Nursery is using a Fifth Amendment argument, which has to do with takings, to kind of bypass this idea that the government can come onto their property. And then, unbeknownst to all of these things, then we have this issue of how can this actually bust a union? So a lot of people are calling this a union busting case, because this ultimately attacks a 45-year-old regulation that California has had, where union workers can access the property. Workers on for instance, this farm can access the property a little bit earlier. So the way that this can potentially create an issue for unions is that it single outs unions for an inferior treatment. And now the biggest concern, especially with Justice Amy Coney Barrett being appointed at the Supreme Court, is that if the justices ultimately vote among party lines or along party lines, we're going to walk into a situation where people they have their opinion made up before they've heard the case, which is a lot of people's concerns about why exactly President Trump appointed somebody so quickly before the election actually happened. But that's another topic for another day. We can get into that later. But this particular case is going to deal with something even more narrow about unions. So if the Supreme Court votes along party lines, if they decide to vote on this narrow issue, we could ultimately walk into a situation where public sector unions are going to be charging fees. And I'm sorry, that's not the correct one. I was reading a different one. The issue is that they're basically not going to be able to organize on the property of the place of employment that they're in. So they're going to have to be organizing off the property, which is an issue because when people leave, obviously when you leave work, you just leave work. You don't come back and say, I'm going to, stay at work and hang out with my friends. A lot of these people are working, significant amount of hours a day. They're going to go home. So the whole point of being able to union organize on the property that you are on is so that you can actually gather and unionize the people that you work with, because ultimately unions are the ones that advocate for higher wages for employees, for health regulations that need to be implemented, and for measures that employers and the government should be taking to make sure that people are safe in their working environment. So this is the situation we're in this case, and the plaintiffs are sticking to this argument about how this kind of taking under the Fifth Amendment is essentially a way to grant an easement. So an easement is a little bit of a very technical legal term, but it's basically an easement is when it's a granting of property. It could come in different ways, and the ways are complicated and nuanced and not really relevant. But the point that the Cedar Point plaintiffs are trying to make is that the regulation that already exists grants unions, and this is what their argument is, word for word, a permanent right to the land that they can invoke against landowners, which means that they will always be able to just take that piece of property, that's theirs, and they can do with it as they want. When in reality, this is not about the taking of a land for just compensation. It's purely about the ability to organize on property. So now I'm going to take some of the comments that were, I think Cameron said that what are union workers, how are they feeling about this whole instance or this whole case? So it's my understanding that this is not something that a lot of people are aware of. And that's kind of what I want to do with this broadcast, or with broadcasts similar, is that this is a particularly relevant issue for a lot of union workers, but people don't actually know about it. So a lot of cases actually that come before the Supreme Court are super relevant to our lives, or super relevant to the way that we live our everyday lives. And they enforce and uphold laws, or they provide context and interpretation to the Constitution. So in this particular case, just like so many cases that come before it and are coming next, it influences or impacts worker safety. And that's going to influence and impact the fruit prices, for instance, strawberry prices, and whether or not employees are going to receive the right kind of health parameters that they have to, employers have to work within health parameters. Are they going to increase your strawberry prices because of it? But also, I mean, we should care about, people around us and make sure that, like, they're not being smashed by a giant machine at work. Like, there should be steps taken to make sure that people are safe. So this is one of those instances where I don't think a lot of people know what's going on. I do think nonprofit organizations are keeping a close eye on exactly the result and implications of what's going to happen. We are going to get a decision spring of 2021, and hopefully by then we'll have some clarity on exactly what the Supreme Court says, which is also another point I wanted to just point out too, is that we can read the facts of the case, we can read the arguments, they're publicly accessible. If you just type in the name of this case on Google, there's actually all of the briefs that come up, which are the plaintiffs and the defendants' arguments. You can read all of those things. You can kind of gather what you can from the legal arguments from a analysis perspective, but there is no true answer, or is no true way to predict how the court's going to actually rule on it, because they're going to rule on it in a specific way along party lines, maybe not along party lines. Those are something that we can't really anticipate. So, we can't anticipate, but we can't predict for sure. So that is kind of where we're at right now, and that we are going to kind of keep an eye on this case. I'll be having a guest come on to this broadcast and talk a little bit about the actual decision when it comes out in spring of 2021. And from there, we will kind of assess where we're at in terms of what this means for workers' rights movements, what this means for labor rights movements. And it's going to be fairly interesting, because this case also dates back. I mean, the history of the labor rights movement and the history of workers' rights in general in the United States, but also in, in California, a lot of times we see a lot of labor and union organizing. It dates back to very, very, very early times of like 1935. So this is not something that's just, a new concept. It's really something that this country has a deep history of, and it has a lot to do with race. It has a lot to do with class, of course. And so it's going to be fairly interesting to see what happens when this all comes to a head in spring of 2021. So I'm just going to go back and read some of the comments again to see if anyone has any other questions. Someone is asking Cedar Point. What is Cedar Point? Cedar Point is the nursery. It is a nursery that grows strawberries, and they have employees that work in the fields. And this is basically about people who wanted to organize at the strawberry farm called Cedar Point, and the strawberry farm told them they can't do that. And that's the simplest way I can put that. All right. Hello from Seattle, LA. Hello, everyone. And thank you all so much for watching this broadcast. I really hope to continue doing these. And if anyone has any suggestions on next cases they would like to see, please feel free to comment on this video and let me know what you're interested in. I hope to be covering the Affordable Care Act next, and also the consequences of having a majority conservative Supreme Court as we head into a Biden administration. And then I also want to cover the court cases that the Trump administration has been lodging at different state courts around the country, and what those ultimately resulted in, which we know some of them, most of them, maybe all of them, are dismissals. So we will go over that, and we will talk a little bit about why that's the case and what that means for January 20th of 2021, and whether Biden is going to be, Vice President Biden will be sworn in as the President of the United States. Which, spoiler alert, he probably will be. But that's all for today. Thank you all for watching, and I hope to see you all very soon.